also blessed with a highly regarded and very appropriate speaker for today, Aziz Huq. Aziz is the Frank and Beatrice Greenberg Professor of Law at the University of Chicago Law School. His teaching and research, and by the way, I told him this morning that I was online looking at one of his classes just to get a feel. And he said, well, that violates Illinois law that was online, so I don't want to get anybody in trouble. But his areas of expertise include constitutional law, criminal procedure, federal courts, and legislation. So I told you he was appropriate. Before joining the law school faculty, he worked as an associate counsel and then the director of the Liberty and National Security Project of the Brennan Center for Justice at the New York University School of Law. You have to really pay attention to figure out where exactly he was. And he was litigating cases in both the U.S. Court of Appeals and the Supreme Court. He clerked for Judge Robert Sack of the U.S. Court of Appeals for the Second Circuit, and for someone you've heard of, Justice Ruth Bader Ginsburg of the Supreme Court of the United States, rock star, notorious RPG. Okay? He has a book coming out, so this is really timely. The book is called How to Save Our Constitutional Democracy. You will have the opportunity to get a % off this book due to the generosity of Aziz. And so you'll be the first one to hear this riff. So he's going to speak, then I'll return and moderate some questions. So Aziz Huq, thank you very much for being here.
Thank you very much, Professor Howie, and all the other organizers at this trip.
We can't hear.
Can you hear me now?
No.
Can you hear me now?
No.
I set him up, sorry.
I set him up.
Well, I would say thank you to Danny, and to Jessica, and to Howie for coordinating this great day and the really terrific lineup. So I'm a professor of constitutional law, and I've written a book with my colleague, who's a political scientist, on how democracies fail. This is something that we've been interested in since 2006 and worried about as citizens. And we want to understand how it happens, mechanically, how it happens. And what I want to do in my 10-15 minutes is to tell you a little bit about what I think we now know about the mechanisms of democratic failure. So a good place to start in thinking about this is with what is perhaps the most notorious and terrible example of democratic failure that the most people comes to mind. Right, the example of the end of the Weimar Republic and the beginning of Nazi rule in Germany. And there was an evening in Berlin, February the 27th, 1933, when a fire started in the German parliamentary building, the Reichstag. Arriving at the Reichstag later that evening, Adolf Hitler famously pronounced that the fire was the opportunity that the party had been waiting for. Later that night, an emergency decree was signed, the Reichstag fire decree, suspending rights to speech, rights of association, the right of privacy and communication, and the right to have a warrant before you were arrested. Now, we all know the rest of that story. Can something like that happen in the United States? No, and yes. Right? Let me play out both of those, the no and the yes, because they're both are crucial to understanding the way in which our democracy is imperiled. So here's the no, right? What the Nazis did was to seize power suddenly and dramatically through the use of emergency authorities contained in the Constitution, right? It was a sudden, violent caesura of democracy. Now, since 1980, there have been 52 instances in which democracy has failed around the world. Out of those, only 5 have involved coups or emergency powers. The abuse of emergency power of the kind that we see in 1953 in Germany is a superseded technology of democratic failure. You just don't see it happen anymore. And there's good reasons to think that it might not happen in the US, which I'm happy to spoke about. Right, so that's a way in which the 1953 example is not a precedent. But there's another way in which I think it is telling but it's a way that is deeply underappreciated. And it's this. The Reichstag fire decree was perfectly lawful under the Weimar Constitution's emergency powers provision. Moreover, what followed it, something called the Enabling Act, enacted by the Reichstag, that suspended the operation of Parliament, that vested all authority to rule in the Chancellor, and that ended elections until 1949, right? That was also perfectly lawful and constitutional. The point that's important about the 1933 example is that the instruments of democratic failure emerged from within the legal and constitutional system of the Weimar Republic, a republic that had been a robust and effectual democracy. Now, it took anti-democrats a while to realize the potential of law and politics, but they have realized it. And in the last 15 years, we've seen a wave of largely populist leaders appealing to broad, miscontented economic management, seizing power in elections, and then employing instruments of law and constitutional change to unravel democracy. Right? This has happened first in Latin America, in Venezuela and Ecuador. It's moved to parts of the Middle East. It's been seen in Eastern European countries such as Poland and Hungary, and one could argue that we've seen some parts of it in the United States. And what's telling, and what's really the focus of our work as legal scholars, is thinking about the ways in which law and constitutions have become not bulwarks of democracy, but tools that can be used to unravel democratic competition from the inside. Looking across the globe from Latin America through to Eastern Europe and the Far East, one sees a standard toolkit of ways in which law and constitutions are deployed against democracy. That toolkit, the fact that there's a common toolkit is not surprising. Countries or anti-democratic forces in different countries are learning from each other and are consciously copying methods from each other. Therefore, there is a diffusion both of political styles, but also of legal technologies to replace the superseded idea of coup or emergency power. And so what Tom Ginsberg, my co-author, and I try and do in our book is to identify the ways, the mechanisms through which democracy fails in other jurisdictions, and to see how strong our laws and constitutions are in the face of those particular threats. Right? We're trying to think about, well, if this was done here, what would happen? So, and we work through a bunch of different domains, and let me just talk briefly about 2 out of the roughly 5 areas that we cover in the book, because I think that they touch on issues that are of present-day salience, contemporary salience. So the first is the idea of independent institutions contained within a constitution that check the use of governmental power. Now, we have a very old constitution, 1787, and constitutions that have been enacted after that, particularly those in the second half of the 20th century, have employed a series of new, innovative institutions like ombudsmen, human rights monitors, election monitors, general auditors. They've embedded those in the Constitution as means of protecting against the misuse of governmental power. Today, the average constitution in operation around the world has 4 such independent institutions. One of the things that we see happening in the early stages of democratic backsliding is that these protective institutions, these checks on the misuse of power, are attacked and gutted, right? That can happen informally, as has happened in South Africa, where President Zuma in particular launched fierce public and political attacks on these various, what are called in South Africa, Chapter 9 institutions. But it can also happen through law. Hungary is a nice example. In 2010, a party called Fidesz took over power in Hungary. They had had a majority of the legislature. The majority was not enough to amend the Constitution, but the rule for changing the Constitution, which required a 4/5 majority, itself was not protected by a supermajority rule. So what Fidesz did is that they changed the amendment rule. And by changing the amendment rule, they changed the Constitution. The new Constitution implemented by Fidesz, one of the most important things it did was to transform entirely the various checking institutions that had been embedded in the previous constitutional regime. The National Bank, right, the equivalent of the Federal Reserve, the media ombudsman that was captured and then that was later used to suppress independent television, to push out of business the billboard company that rented public spaces to Fidesz's opponents, and public office. Right, these were all Well, could something similar happen in the United States? Hold on. So the first problem the United States has is that we have a really old constitution. And the constitution hasn't learned from the changes in legal technology that emerged in the 20th century. So we just don't have at the constitutional level the safeguards that other jurisdictions have, right? So someone coming into power doesn't need to change the constitution in the way that Fidesz does, because the constitution itself doesn't contain those safeguards, right? Where those safeguards exist, they are a function of either a statute or of norms or customs within the executive branch, right? And I'm sure that Ian Masson and others this morning talked about the ways that those norms, customs, and statutes have come under pressure. But let me just flag one detail. On the judicial right in the last 25, 30 years, has emerged an idea called the unitary executive theory. What the unitary executive theory does is it takes the fact that we have a single president, not a council, and it infers from that fact the illegality, the unconstitutionality of constraints upon the president's power to fire or control people below the president. And the problem with the executive, the unitary executive theory, is that it has no limiting principle, right? So today, there is one lawsuit in which, on unitary executive grounds, the power of Special Prosecutor Robert Mueller is being challenged as a violation of our separation of powers, right? So it's not just that our Constitution fails to contain the kind of safeguards other jurisdictions have. It also, in the form of the unitary executive theory, has a turnkey that allows unraveling of those statutory and custom-based safeguards that do exist in the form of special counsels, in the form of the Office of Government Ethics, and the like. That's one example. Here's the second example, then let's forward. Courts. In many jurisdictions, courts have been a really important safeguard against democratic backsliding. So, for example, in Colombia, in 2012, the Constitutional Court said no when President Alvaro Uribe, a very, very popular president, ended the civil war there on the farm, said, I want to run for a third term of office and I'm going to change the Constitution to get rid of presidential term limits. It was the Constitutional Court that stood in the way of that movement. In South Africa, the Constitutional Court, when President Jacob Zuma was charged by the public protector, one of these independent institutions, with the misuse of public funds. And when Zuma said, fine, okay, I don't have to do whatever the public protector says I should do in terms of remedying, that's just advice. The Constitutional Court stepped in and said, no, you, Zuma, and your cronies in Parliament have to follow through with these remedies. Courts are really important. It's therefore no surprise that in many democratic backsliding cases, courts are also among the first institutions to be attacked. So we see this, for example, in a number of different ways. My favorite example is from Poland. In Poland, the Law and Solidarity Party comes to power. They don't have a majority that allows them to change the constitution. But it turns out the retirement age for judges is not in the constitution, it's in the statute. So they just changed the retirement age. They lowered judiciary by political branches, and that was used even prior to the attempted coup of 2016 to purge the judiciary of opponents to the president there, Recep Tayyip Erdogan. Now, what's the risk of that happening in the United States? Well, in the United States, judicial independence is protected only at the back end, right? Our Constitution in Article 3 says that judges shall serve during good behavior, okay? It doesn't say anything about, it doesn't regulate the selection of judges to ensure judicial independence. To the contrary, it vests the selection of judges, as we've seen, in political branches, right, in the Senate and the presidency. Does that make sense? Well, Alexander Hamilton in Federalist 78, one of the documents that was produced during the ratification debate, explaining the design of the judiciary, said, look, judges are going to be independent, they're protected at the back end by good behavior, but at the front end, we don't need to worry about bad kinds of selection because there are so few people who understand the deep complexity of the British common law and the American colonial experience that there's going to be no hanky-panky in the selection of judges because there's only a few men who can play that role. Maybe the men don't stay the same. Right? Okay, so clearly the constraints at the front end that the framers assumed to exist don't obtain anymore. And the operation of the Senate as a predictably partisan institution, an institution which demographically is tilted in one partisan direction, means that we have a functionally, it is quite possible, and one might argue has occurred today, that it's quite possible to have a court that is closely, functionally aligned with a particular political party. There's nothing to prevent that from happening. And if that happens, the back-end constraints that take the form of judicial behavior become pathological. One more point, and then I'll finish. I think that there's a nice little wrinkle, I mean I say nice, but it's nasty, a nasty little wrinkle that's arisen with respect to the Kavanaugh nomination and confirmation. As many of you know, there are credible arguments that Justice Kavanaugh committed perjury, right, during his confirmation proceedings in a number of different ways. There is therefore a risk that he will be impeached. The risk is asymmetrical. There is no risk that he will be impeached if there is a Republican House and Senate. There is a risk that he will be impeached if there's a Democratic House and a Senate. Accordingly, above and beyond ideology, we now have a member of the Supreme Court who has a direct and personal interest in maintaining a particular political party in power in the House and the Senate. And there are ample ways in which his role as a justice gives him the power to do so. This is a historically unprecedented situation. So if we're thinking about judicial independence as a check on democratic backsliding, as a check on measures or changes that reduce the quality of our democratic competition over time, right? We have to think really carefully about the way that the founders designed may today operate in ways that were unpredicted by the framers themselves. So I look forward to your questions.
So thank you very much. I think I should have had that cookie after lunch because I need the lift from the sugar when I eat that sobering assessment. Maybe I'll have that after. I'm going to ask you ask questions, not make statements, because we have, as is abundantly evident, we have a very thoughtful panelist here, and we want to hear from you. So please, shall we? Maybe I'm closest. All right. Oh, you got it.
I actually have two questions relative to what you were saying. One is, don't ever fault this whole issue in the Senate is the nuclear option where they changed from majority, from 2/3 to majority in electing or approving the Supreme Court justice.
Yeah.
I'd be interested to hear your comments about that. And secondly, I think I've been hearing a lot about a new constitutional convention that people are attempting to call. And I'd like to hear your thoughts on that.
So that's a very big topic. On the supermajority rule, the supermajority rule was initially abolished under Harry Reid with respect to local judges in response to the use use of delays and impediments to the nomination and confirmation of judges by President Obama. One can argue about who was to blame for Reid's decision to abolish the filibuster rule during the Obama presidency. My view is that it was the Republicans that initiated the circumstances in which the filibuster rule became untenable. It was very predictable that that rule would be abolished with respect to the Supreme Court when we get to a McConnell-Trump configuration of power. The effect of that rule is, or the effect of the abolition of that rule, is to make possible the appointment of judges who are further, or that are at least now further to the right. In other times it might be further to the left, right? But it makes it more likely that judges will be more rather than less partisan. And one kind of slice of reforms that you might want to think about is how do you make judges and justices in particular less partisan rather than more partisan. I'm very skeptical that you can do that because the Senate is so heavily biased demographically in favor of certain states, like California ends up getting the short end of the stick, I'm sure you all know. And the states that are overrepresented in the Senate tend to be Republican states, right? So the Senate itself is deeply problematic as an appointing institution, but the abolition of the filibuster rule, the 60 senator requirement, I think exacerbates that. Constitutional Convention, Article 5 of the Constitution gives a couple of different ways in which the text can be amended. It turns out we amend the text all the time in all sorts of different ways. But formally, it is possible to have something called a Constitutional Convention. The last one of those that we had was in 1787. So nobody has any clue what that looks like. The current push to have a Constitutional Convention is largely funded by the Koch brothers, and it's largely focused upon balanced logic amendments. My sense of what would happen if there was a convention is that, man, if you felt the confirmation process for Kavanaugh was crazy, that would be crazy squared or cubed.
Thank you very much. Was there a question on this side that I missed? Yes, please. Do we have a microphone on this side?
You speak about the weaknesses in our current political system. Do you see any path to overcoming those or protecting us from those failures?
I think you have to think differently in the short versus the long term. I think in the short term, there is a question about how the behavior of those who are elected in the coming 2018 and 2020 cycles behave. And so I think that the election is very important. I'm not going to say how I think people should vote. In the medium term, I think reform is really important. My tendency is to think, consistent with my answer to the last question, that massive reform at the level of the Constitution is just impossible. Right? It's just too destabilizing, and we just don't have the levels of social consensus that allow us to do that. And it's like rolling the dice. And so, consistent, I'm now looking directly at Ian, consistent with what Ian Bass and others have said, and consistent with what we say in our book, I think that there is lots and lots and lots of incremental piecemeal reform that does little bits here, there, to improve the situation, but man, if you're looking for something that makes things better overnight, it's just not there. It's just not going to happen.
Thank you. Yes, here in the middle.
So the United States is probably the only democratic country that does not guarantee constitutionally the rights of women. And both parties and at times when they have majority in the Congress failed to pass such constitutional amendments.
Yes.
How do you see the future of women and of democracy in our country?
Right. So I'm extremely sympathetic to what you're saying. I get really annoyed when my colleagues say, "Well, we've had a democracy for 200 years." Like, no, women couldn't vote until 1919. How on earth do you describe a country in which half the population cannot by law ever vote as a democracy? It's not. No, crazy. What you're pushing on, however, is the Equal Rights Amendments and the current push at the state level to adopt the Equal Rights Amendments to the Constitution, right? My view is that an equal rights amendment, at least as currently formulated, would not do useful work above and beyond what constitutional law now does. What constitutional law now does, as a function of the interpretation of the Equal Protection Clause of the 14th Amendment, pushed by my former boss when she was an advocate, actually does an awful lot, right? What the law professors call the Gender Equal Protection Law, right, is pretty darn good. It's way better than the law of race, right? The law of race is utterly regressive and ensures that government cannot do many things that would ameliorate social stratification, right? The law of gender it does not look like that, right? And I am skeptical that you can improve the law by passing an equal rights amendment that on its face doesn't change much. Right? I will say one thing that I think is really important. There are ways in which the Roberts Court and the Rehnquist Court have restricted the government's power to grant remedies that are deeply consequential for the issues that you're describing, right? So I would not focus upon the Equal Rights Amendment. I would focus, I'm a law professor and I'm a little in the weeds. I would focus on the fact that the Supreme Court has it has once invalidated, twice, the second time it came close, but didn't. It has invalidated really important parts of the Family and Medical Leave Act, right? It's invalidated a part of the Violence Against Women Act that provides civil remedies for victims of domestic violence, right? I would focus on the fact that we now have a Supreme Court with two people against whom there are credible allegations of sexual abuse, right? There are many ways of addressing your question, and not all of them involves equal rights.
Thank you. I'm advised we have time for one more, so Aharon Chaviv, the chair, Marty Shanker.
So much pressure on that question. So you and some of our earlier panelists talked about this worldwide trend, the unraveling of democracy. Are there any success stories in the last generation, even if incremental? So what did they do right?
Well, I can't sell you this, but because it's an academic article that's about to come out in the Journal of Democracy, but we actually try and answer this question by looking at cases in which democracy has suffered, but then has come back from the brink. We call these democracies near misses. And we find a couple. Sri Lanka and Colombia are the examples. There's an older one in Estonia that is interesting for different reasons. So the counterintuitive lesson that emerges if you start to look for those cases in which democracy is in trouble that survives is that it's really important to have strong, non-majoritarian institutions, right? In Colombia, what saves democracy is the Constitutional Court, right, which is not a majoritarian, not an elected body, right? But they step in and they prevent Uribe from abolishing term limits. What saves democracy in Sri Lanka against a populist leader called Rajapaksa is an election body, the Elections Commission, that refuses to rig the election. Right? They just say no. And then when Rajapaksa loses a snap election, he telephones the military and says, I want you to go out on the street. I want a coup. Right? And the military commander says no. Right? So and it's a similar story back in Estonia in the 1930s that explains why you don't have a kind of rightist anti-populist move in Estonia in the same way you have in Germany. What turns out to be really important to democracy in moments of crisis is absolutely, it's what people like you do, right? It's what the people do, but it's really important to have robust institutions of government that are willing to stand up for the idea of democratic competition as an ongoing concern.
So on that note, I want to say now the list has grown to 4 of actions you need to take. Subscribe to the Chronicle, donate to KQEDs, Fresno Bee, and purchase this book, How to Save a Constitutional Democracy. I want to thank Aziz Huq for not just for coming here and spending this time with us today, but more importantly, what you do every day in defense of constitutional democracy. We really appreciate your work. So thank you.